Greetings and welcome to Debunking Legal Interpretation Myths, a critical examination of common misconceptions in legal textualism. Now, just before we get started, remind everyone this is strictly for the education and entertainment purposes of this YouTube broadcast, not to be used misconstrued for anything legal, lawful, personal, private, business, personal, or otherwise, so please don't do this at home. All right, let's continue. So this is from the book about reading law, authored by late Justice Antonin Scalia and Brian A. Garner, and it was a comprehensive legal guide to interpretation, and it presents 57 sound principles of interpretation and exposes 13 common falsities in legal interpretation, which we'll be going over in this broadcast. And it emphasizes textualism as the proper approach to interpreting legal text. So, to the strict text of the law as it was written, with language at the time it was written, without looking too deeply into the intent of those that wrote the laws or the legal text. That saying, it's a part of the, not that I would say I subscribe to fully his views on this and his perspective, but I still want to be able to entertain these ideas without necessarily accepting them, so we can judge them for our own, whether they have legal value or personal value, etc. So let's start with this. The first falsity is number one, the spirit versus the letter of the law. And here's his misconception. The false notion that the spirit of a statute should prevail over its letter. So here's how they go about debunking this. Scalia and Garner argue that the text itself is paramount. The spirit of the law is often subjective, and it can lead to judicial overreach. Textualism requires adherence to the actual words used in a legal text, not an imagined spirit behind it. This is something which could have, we'll get a little deeper into as the text goes on. So keep that one in mind. Falsity number two, the quest for justice. And before we do go on, just to think here, this is something where letter of the law should be a way to remember this as we get back to that topic. Falsity number two, the quest for justice. Misconception. The false notion that the quest in statutory interpretation is to do justice. And here's how he goes about debunking it. The proper role of a judge is to interpret the law as written, not to achieve what they personally consider just. Justice is the aim of legislation, not interpretation. When judges pursue their own vision of justice, they undermine the democratic processes and the rule of law. Not my words here. Let's proceed. Falsity number three, reconstructing legislative intent. So here's where we get back to the letter of the law now. Misconception, the false notion that when a situation is not quite covered by statute, the court should reconstruct what the legislature would have done had it confronted the issue. And the authors go about debunking it by saying the court should not engage in imaginative reconstruction of legislative intent. It's imaginative reconstruction of legislative intent. This practice invites judges to substitute their own policy preferences for those of legislature. The proper approach is to apply the text as written, acknowledging that gaps in legislation must be filled by the legislature, not the courts. So to defer to the legislators for those. That sounds like a sound plan in a lot of cases. However, it's not always an imaginative reconstruction of legislative intent, as we will get to soon. And we're on to falsity number four, consequences as a key to interpretation. And for any of you that just arrived, please hit the like so we can get the notifications out there and get more people to contribute here in the chat as we continue on here. This is somewhat of a controversial topic here about textualism versus the I guess intent interpretation, however you want to say it. But it's really fundamentally about that spirit of the law versus the letter of the law, and which conveys the intent more truly. And this is where the perspective of Scalia is being articulated here through this book. Let's continue. Falsity number 4, the consequences as key to interpretation. The misconception is that the half-truth, that consequences of a decision provide the key to sound interpretation. The half-truth, that consequences of a decision provide the key to sound interpretation. So the consequences, looking at the end result of it as a key to interpretation, I could see this as being a serious misconception. So let's look at how he goes about debunking this. While consequences may be considered in some circumstances, they should not drive interpretation. Focusing primarily on consequences allows judges to substitute their own policy judgments for those of the legislature. The text itself, not its anticipated effects, should guide interpretation. That's probably a very good statement right there, that the text itself, not its anticipated effects, should guide interpretation. So I have to agree with that one there. And number 5, falsity number 5, strict construction. Here's our misconception, the false notion that words should be strictly construed. And debunking it, Scalia and Gardner argue that strict construction is not a doctrine to be taken seriously. Words should be given their ordinary meaning, neither narrowly nor broadly construed. So, ordinary meaning. So for regular people in their common sense of the time, neither narrowly nor broadly construed. The text itself determines whether it should be read broadly or narrowly, not a preconceived rule of construction. So the text itself determines the level of precision. That does make sense there, but it may not always be easily determined from the text itself. But the text, it does lend itself that way with its own contextual clues. Indeed, that would be a beneficial way of interpretation by letting the text itself determine whether it should be read broadly or narrowly. Hey, and we have Captain Jack in the house. Better take orders from the captain here and hit the like, folks. Otherwise, you'll have to walk the plank. Falsity number 6, strict construction of exemptions. Misconception. The false notion that tax exemptions, or any other exemptions for that matter, should be strictly construed. Debunking. There is no sound basis for applying a rule of strict construction to exemptions. Like all other legal text, exemptions should be interpreted according to their ordinary meaning. The text itself, not a categorical rule, should determine the scope of an exemption. So this is interesting here, that the text itself, again, determined the scope of the exemption. So the text itself, we have to discern from the text not only the precision, level of precision, but also the scope when it comes to an exemption. So I can see this here getting into the finer details of adjudication, indeed. All right, we're on to falsity number 7, liberal construction of remedial statutes. So the misconception here is the false notion that remedial statutes should be liberally construed. And the authors go about debunking it by saying that the label remedial does not justify departing from ordinary meaning. All statutes should be interpreted according to their text, not based on their perceived purpose or category. So the categorical one here. The rule of liberal construction for remedial statutes invites judges to expand statutes beyond their textual limits. And that's, I know what the word remedial means, but when we say remedial statutes, it seems like we're talking legal terminology. And when that's the case, it behooves us to go over to Black's. And so we're looking, let's see here, remedial statutes. So we could start with remedial and then come to statutes because this is a scanned document and R comes before S. So just bear with us a second here while we wait for the scanned document to catch up with where I just scrolled it to. It could take a while. In the meantime, we can notice any serendipitous definitions that pop up along the way. Personality theory, a rationalization of intellectual property laws. Personality theory. Way of analyzing intellectual property. All right, I think we're caught up now here before I digress too far. And we're looking for remedial P. Let's get over here. Don't want to jump past it. We'll edit this part out. All right, here we go. Request. There's a good one here, res. We're going to come back to that in a minute, but let's look see if we have our remedial statute. I don't think it's going to be here. Oh, man. Almost there. Enunciation. You're almost there. There's remedial. Affording or providing a remedy, providing a means of obtaining redress. Wow, okay, a remedial action. Means of obtaining redress, intended to correct, remove, or lessen a wrong, fault, or defect. A remedial statute. There we go. Intended to correct, remove, or lessen a wrong, fault, or defect. A remedial statute. So they found a defect or a wrong or a fault in a statute, so they issue a remedial one. Oh, I get it. Okay. Of or relating to means of enforcing an existing substantive right, a remedial right. Okay, so we got the remedial statute. It was intended to correct, remove, or lessen a wrong, fault, or defect. Okay, so let's get to res here because we came over that on last night's stream, and it'd be a good idea to look at it again here. Some of the words that we come across so much, it sometimes evades us to remember the significance of their roots, like resident, and there we go. Raise, res, or res. So res or raise. Raise is probably the proper Latin for that. It comes from the Latin, the thing, an object, interest, or status, as opposed to a person. So jurisdiction of the res, the real property in Colorado. Okay, the jurisdiction of the res, an object, interest, or status. The subject matter of a trust, corpus. So there we go. So think of it as thing. Res means thing. The object, interest, or a status. So if we went to resident, just down here a little bit, we'll edit this off too here. So we have resident. Residence, let's look at resident first. All right, affiliated with working with or working for a particular person or company. 2, a dwelling in a place other than one's home on a long-term basis. That's an adjective, so a resident. So this is a resident tenant. Here, a resident is a noun, 15th century, a person who lives in a particular place. That's it. A person who has a home in a particular place. That's definition 2. We have lives or has a home. In sense 2, a resident is not necessarily either a citizen or a domiciliary. So it's not necessarily your domicile if you're a resident. A resident is not necessarily either a citizen or a domiciliary. And then we look over here at residence, comes from even the 14th century, the act or fact of living in a given place for some time. So a year's residence. The place where one actually lives as distinguished from a domicile. So a residence is distinguished from a domicile. Residence usually means bodily presence as an inhabitant in a given place. Domicile usually requires bodily presence plus an intention to make the place one's home. A person may thus have more than one residence at any time, but only one domicile. Sometimes, though, the two terms are used synonymously, sometimes. So we see here habitual residence and family law. This is the term from the Hague Convention, geez. So we see here that resident and residency have very distinct meanings outside of domicile and inhabitant. All right, with that said, let's proceed back to the presentation. Thank you for that. Tagging along with that digression there. There we go. So we're back to the falsity here. Let's just read this again now that we know what remedial statutes are intended and where they come in. The misconception, the false notion that the remedial statute sent to correct the wrong, defect, or fault in another statute preceding it should be liberally construed just because it was put in place to fix a defect of one. The label remedial does not justify departing from ordinary meaning. So the meaning of the remedial statute is still construed from its textual, just I guess you could say literal meanings there, from ordinary meaning, not even literal, ordinary meaning. All statutes should be interpreted according to their text, not based on their perceived purpose or category. The rule of liberal construction for remedial statutes invites judges to expand statutes beyond their textual limits. So this sounds like a sound way of interpreting law. We're on to falsity number 8. We have St. Frog Dog Welcome says, they don't like people like me to bring up the difference between a resident and an inhabitant in my area, and they get so mad when you got the proof. Well, we just saw the proof there. I didn't really have any intention to bring up that level of detail. I was looking up res, but then seeing how was applying to, it's not applying to your intent to live there, so just applying to a place. Okay, so we continue. Falsity number 8 is the express language for jurisdiction. Misconception. This falls right in what we were just discussing. The false notion that a statute cannot oust courts of jurisdiction unless it does so expressly. So here we are debunking it by the authors. The statutes can oust courts of jurisdiction through implication as well as express language. The key to whether text read in context clearly indicates an intent to limit jurisdiction. So there's a key. Whether the text, again, read in context, clearly indicates an intent to limit jurisdictions. Now, from the text, we have to interpret the precision, the scope, and now what we have here, the intent. So there's a lot to read into the text according to the authors here. So far, I'm trying to keep a list. Anyone can pipe up in the chat and add anything I miss. Requiring express language for jurisdictional limitations would undermine the legislature's authority to structure the judicial system. Something wrong with that. legislators' authority to structure the judicial system. Well, either way, the author's point there, that's another one that we would say is the jury's still out on. Okay, we're on to falsity number 9. Legislative history as an aid. We've heard this before. Misconception. The false notion that committee reports and floor speeches are worthwhile aids in statutory construction. He claims that's a misconception. Let's see. What do we got here? Debunking. The authors say that legislative history is often unreliable and subject to manipulation. Committee reports and floor speeches do not undergo the same deliberative process as the enacted text. Relying on these materials undermines democratic accountability and invites judges to select materials that support their preferred interpretation. I'd probably have to differ on this one because we have some pretty extensive congressional records that are in the archives and are correct. They are reliable. And those are the deliberations and a lot of the input from the representatives in the legislature that do articulate a lot of the intent that creates the enacted text and comments on it. So I would say that actually committee congressional reports and things like that are invaluable to really getting an understanding not just of the intent, but the feeling of the time when it was written to even help with the textual interpretation. But that's my opinion, and I digress. Let's continue. We're on to falsity number 10. Discovering intent. Misconception. The false notion that the purpose of interpretation is to discover intent. Debunking. The purpose of interpretation is to determine the meaning of the text, not to discover the intent of its drafters. Legislative intent is often a fiction, as legislatures are collective bodies with multiple, often conflicting intentions. The text itself, not speculative intent, should guide interpretation. So now I'm starting to see why he uses the word democratic so much in the text, because this is kind of a winner-take-all attitude to interpretation. Let's continue. And we're on to falsity number 11. Plain language as evidence of intent. Plain language. Misconception. The false notion that the plain language of a statute is the best evidence of legislative intent. Debunking. While plain language is crucial for determining meaning, it is not evidence of legislative intent. The text meaning is what matters. So it's not the plain language determining meaning because of the plain language, the category or the style. It's the meaning itself of the language is what matters, not what legislators intended. This misconception incorrectly assumes that the intent is the proper object of interpretation and that the text is merely evidence of that intent. I see where he's coming at with that. At the same time, what is the purpose of codifying laws in the first place? Unless there was an intent, what would be the purpose of doing it? It starts to be begging that question. But I digress once again. Let's continue. And we're on to falsity number 12. Historical research qualifications. Misconception. The false notion that lawyers and judges, not being historians, are unqualified to do the historical research that originalism requires. Debunking. So the authors claim that lawyers and judges are capable of conducting the necessary historical research for originalism. Legal interpretation often requires understanding historical context, and the lawyers are trained to research and analyze evidence. The suggestion that only historians can understand original meaning is an attempt to discredit textualists and originalist approaches. So, yeah, I guess this is again the categorical assumptions here creeping in terms of like originalism and textualist, as if they're exclusive categories of people, which I don't quite subscribe to, but I digress once again. We're on to falsity number 13, the living Constitution. Misconception, the false notion that the living Constitution is an exception to the rule that legal texts must be given the meaning they bore when adopted. And here he goes about debunking it. The living Constitution approach allows judges to update constitutional meaning based on contemporary values, undermining the amendment process. Okay, I think we can agree with that one. All legal texts, including the Constitution, should be interpreted according to their original meaning. If that meaning is no longer suitable, the proper remedy is amendment, not judicial revision. And I think that's a pretty key point as well. And another fact of this is that the original meaning, again, having to be interpreted from the text requires some of this historical research. And terms like originalism and textualists, I think, takes away from the fact that the highlighted terms here are key, the historical research. And again, the meaning has to be interpreted. So the meaning of the text requires that historical research and having that type of open-minded approach. Again, to be able to hold ideas that you may not necessarily accept, but at least entertain them long enough to give them a fair analysis and to articulate that in both ways. So we're on to the key takeaways. So textualism provides principled interpretation, which we did indeed see. The text itself is what guides interpretation, not intent. So again, it was basically it's assumed or presumed that the legislatures, when they enact laws, that they were done fully, all the ambiguity was removed. It's gone through enough deliberations and committees and revisions, etc., in order to make it so that there could be no misconstruing of its intent because of the very careful nature of the words. These people have used grammar very properly. Everything is supposed to be aligned with the facts they're trying to convey. The intent should be clearly articulated within the language. So that's what they're assuming here with that textualist approach, that the text itself is what guides the interpretation, not the intent, because the intent is embedded in that text now because of the deliberative process. Limited judicial discretion preserves democracy. And ordinary meaning at a time of adoption. So ordinary meaning, again, that historical context at the time of adoption. Rejecting falsities leads to predictable interpretation. Predictable, but not necessarily always correct, perhaps. And strengthens the rule of law and accountability. And that may or may not be, to some degree, part of the approach that is promoted here by late Justice. Well, that said, I'd like to thank everyone for attending this quick debunking of legal interpretation myths from late Justice Antonin Scalia and Brian Garner. A nice book. Again, judges and their books and their writing are not necessarily the easiest to digest for a YouTube channel, so I put it together into this presentation so we can at least get through the 13 myths rather quickly, and hopefully it's left some kind of impression where we have a better informed perspective when it comes to this discussion between the textualists and the ones that look to the intention of the laws as written. And I think there's a fine line there, and somewhere in between is where the truth truly lies. That said, thank you all for coming, and I'll see you all on the next one. Peace out.